Welcome to Law Minds YouTube channel. Today we will learn about tort and tort of nuisance. Let's begin with what is tort? Tort is basically an unlawful act or omission that arises in injury or harm to any person is known as tort. Tort is a civil wrong that can be caused intentionally, unintentionally, negligently, or accidentally. Tort is described under Section 2, Clause M of Limitation Act of 1963. Tort means a civil wrong which is not an exclusive breach of trust or contract. The aggrieved party can file for a civil suit in the court of law. The plaintiff can receive the damage in form of unliquidated damages or etc. The defendant in this case of tort is required to compensate the plaintiff for the damages happened. Tort simply is a wrong that is committed against other person intentionally or unintentionally which gave rise to an harm or injury to that specific person. Tort is described under Section 2 Clause M of Limitation Act of 1963. Next is what is tort of nuisance. The word nuisance is derived from the French word nuire, which simply means to hurt or to annoy, and the Latin word for nuisance, nocere, which means to cause harm. Nuisance is an injury of a person's right to enjoy the possession of the property and the enjoyment of any other person which unreasonably or unlawfully disturbs the aggrieved party's right is said to be constituting tort of nuisance. In simple terms, it means an inconvenience caused to one party by the other party while enjoying their own rights on their own property, but in such a way that affect the former. According to Stephens, nuisance is anything done to hurt or annoyance of the land, tenements of another, and not amounting to trespass. According to Salmond, nuisance consists in causing or allowing to cause without lawful justification the escape of any deleterious thing from one's land or from anywhere into land in possession of the plaintiff, such as water, smoke, gas, heat, electricity, etc. Tort of nuisance is a wrong that is committed against a person's right over their own land during the enjoyment of the other person's right over his own land, but in a way which affected the rights of the former. Now, what are the essentials to constitute tort of nuisance? Wrongful act by defendant. The first essential to constitute tort of nuisance is an omission of any act which is unlawful in nature and infringes any right of the plaintiff's property. Damage or loss caused. Any inconvenience or annoyance is caused to the plaintiff, and the law should consider it as a substantial material of claims. Now, what are the kinds of nuisance? First is public nuisance. Public nuisance is the annoyance or disturbance caused to a large number of people living in the society. Any nuisance caused to the member of the society by a person while enjoying his or her right over his or her property. Instances where an individual can claim for any private actions in the public nuisance are: he or she should prove that a higher degree of damage is caused to the plaintiff than the other person in the society. The injury to the plaintiff should be direct and not consensual. The effect of the said injury should be huge in nature. The second type of nuisance is private nuisance. Private nuisance is the type of nuisance that is caused by damaging one's right over the property while enjoying the possession of their own property. That means a person's enjoyment of exercising the right over his property is disturbed, annoyed, or ruined by any other person during the enjoyment of his rights over his property. But it should injuriously affect the owner of the property or physically injuring his property or the enjoyment of his right over the property. Unlike in the public nuisance, the disturbance in this case is caused to an individual and his right over the property. Now, what are the remedies for nuisance? First is injunction. An injunction is basically an order of restraining a person from doing any act that may be dangerous or can cause harm to a person's legal right. Injunction can also be called as the stay order from the legal authority over any omission of injurious act. It may be in the form of temporary injunction, which is a restraint order over any act that is observed to be injurious for a limited period of time. But if it is confirmed, then it becomes a permanent injunction. Second is damages. Damages is offered in terms of compensation of the harm to the aggrieved party by the person who is said to cause such harm. This compensation is in the form of unliquidated damages, which means that the amount of compensation for the said damage will be on the discretion of the court, as the parties involved in the tort did not know each other beforehand. Third is abatement. Abatement means the understanding of the nuisance created by the aggrieved party. This remedy is never recommended by the law, but it still is an option so that it can be used according to the circumstances of both the parties, and the action of the parties involved should be reasonable. This remedy should be used before the prescribed time and requires a notice of problem to the defendant. These were everything one should know about tort of nuisance. I hope you find this video useful. Thank you so much.